26-831-880 Richt, R-I-C-H-T versus Affinity Lifestyles et al. And there's other plaintiffs and other parties to that case. Remember, on this case, there is a media request that has been granted by this court, so only those subject to that media request, of course, are allowed to photograph, record, etc. Anybody else, of course, is under the other rules where you cannot do what you can't do unless you have a media request. So like I said, those under the media request, more than welcome to do everything consistent therewith. Anybody who's not, you're of course more than welcome to observe, be here, etc. But so we are moving forward with regards to that. Let's walk through our appearances on behalf of plaintiffs. Who do we have, please?
Good morning, Your Honor. This is Brianna Switzler, bar number 15653. And I'm only on behalf of plaintiffs Matthew Gonzalez, plaintiff Agnes Alexander, and plaintiff Sylvia Adesnova.
Thank you very much for that clarification, since we did see the motion to withdraw on Richt, who's the subject of today's motion. Thank you so very much. Okay, next we're going to go to Scientific Instruments International. Mr. Rasmussen, can you do all your appearances, please?
Yes, I can, Your Honor. This is Attorney Scott Rasmussen on behalf of SID International, SID US, and Hannah Instruments, Inc., under Rhode Island Corporation. Thank you.
Counsel, you also Hannah Instruments, Inc.? I didn't hear that. It cut in and out, so I wasn't sure if you said Hannah.
I did, Your Honor. I apologize. If I'm still kidding, I apologize.
Oh, no worries. I just, okay. So now let's go to...
I am here for Hannah.
Pardon?
I am here for Hannah.
Okay, thank you so much. Okay. Next, NSF International, and then any other clients. Go ahead, counsel.
Good morning, Your Honor. Martin Little with Howard & Howard on behalf of NSF International.
Okay. Nevada Beverage, please. Anybody on Nevada Beverage? No? Okay, Milwaukee Instruments, please. I thought somebody did make an appearance. Are you not there anymore? Milwaukee Instruments?
Your Honor, this is Elizabeth Lowell. For Milwaukee Instruments, I couldn't unmute fast enough.
No worries, no worries. WFM, Southern Nevada, and other related entities. Counsel, go ahead, please.
Good morning, Your Honor. Jim Neale, Pro Hoc Vice for Whole Foods Market, WFM, as well as United Natural Foods West.
Okay.
Good morning, Your Honor. David Spurlock, appearing with Mr. Neale for same parties.
Appreciate it. Thank you. Costco, please.
Good morning, Your Honor. Daniela LaBounty, bar number 13169, on behalf of defendant Costco.
Real Water and Affinity. Go ahead, counsel, please.
Good morning, Your Honor. Nathaniel Carlson for defendants Real Water, Inc. and Affinity Lifestyles.com, Inc.
Do we have a bar number?
Yes.
Okay, we do. Okay. Okay, thank you. Okay, so that takes care of the plaintiff and defendant roles. Anybody who's not had an opportunity to make an appearance, that may be in the third party role or else, that needs to make an appearance, anybody else? No, okay. Then what we have here today is I'm going to once again remind you all of your obligations under the EDCR, right? Courtesy copies. Please do ensure the court has them. Please do comply with court rules, particularly those, right? Both that goes for both Pro Hoc Vice and Nevada Council, right? There's obligations. Please do so. I'm also going to remind parties that there's per se non-compliance with a different EDCR with regards to exhibits being numbered. When people submit 89-page documents and expect the court to go fish through all that document rather than providing the appropriate numbering. EDCR 2.27 is alive and well. Please do comply, because the first thing this court has to address is whether or not I can hear today's motion because of said non-compliance in said motion, the underlying motion. And the challenge here is we got a due process issue with somebody who's not here. So I, of course, am going to have to address that and whether or not they would think whether I should be moving forward today or not because of the failure to comply. So feel free to sit down, stand up, whatever you'd like here in court, but let's address, so I'm going to set forth what the motions we currently have, and joinders there too, and then as I noted, we'll go through the procedural issue first, and then determine whether I can even move on. So It is document 320, was Defendant United Natural Foods West and WFM Southern Nevada's motion for summary judgment, and Plaintiff Jesce Richt's claims only. I have a Hannah Instruments Joinder non-substantive, which is document 321. I have Affinity Lifestyles non-substantive joinder, which is document 324. And I have NSF International Joinders, document 320. Excuse me, that's not 324. Give me 1 second. I'll have to double check what that document number is. One moment, please. Give it handy. Oh, sorry, 326. Thank you so much. Okay, so movements are Defendant United Natural Foods West and WFM Southern Nevada. So, counsel, feel free to, whoever's going to do the oral argument, please address first the procedural issue, and then we'll see if I can even move forward today.
Your Honor, it's our law.
Remember, appearances,
I'm
please.
sorry, Your Honor. David Spurlock, United Natural Foods West, bar number 2565. Your Honor, it's our firm who's filed this motion. Mr. Lou Brandon of our firm filed it. The numbering of the pages, I have to apologize to this court. It's certainly an oversight and inadvertence on our part. You certainly are familiar with the 8th District Court rules, so we apologize to the court. I think it's a situation where the court, I would suggest, can in fact move forward. It's a harmless error type situation.
It's a dispositive motion, though, counsel.
I understand.
How is it harmless error? Because you've got, and you can appreciate, well, first off, you don't even actually have your Pro Hoc Vice counsel even on the pleading, so that's an interesting question in and of itself, but that's a different issue. But counsel, as you know, at least this has been represented to this court, and somebody might need to update me on the status in case the recent understanding is that you have an individual who's a pro se litigant who's incarcerated, correct?
He is no longer incarcerated, Your Honor. My understanding that Mr. Richt has been out of incarceration at least for 3 weeks and possibly a month. And I'm not quite certain for that date, but he is no longer incarcerated and hasn't been incarcerated for a period of time.
Wait, so how did, okay, so hold on a second. I didn't see a reply in this, so how do we know, you're raising a different issue, but which is how do we know that Mr. Richt received the actual underlying motion?
Your Honor, I would
given this status, since we're not sure, that's the reason why the court has to ask it, right? Because your motion was filed on 3/28. You say it's been about 3 weeks or so?
That's my understanding, Your Honor, yes.
And I appreciate the candor to the court, but you realize mathematically that hits it right about the time that this motion was filed, right? So how do we know that Mr. Richt actually received notice from a due process standpoint on this motion?
My understanding from speaking to those involved who served this, that there was a service on Mr. Richt. I don't know if it was his last known address or if they attempted to serve him at the Clark County Detention Center. I cannot answer that, Your Honor.
Okay. And
My understanding, it was not at Clark County.
hold on a second. That's not what I thought the certificate. There we go. That's what I thought. The certificate of service, and the reason why the court was asking the questions, the certificate of service does say Washoe County Detention Center was mailed to him. But it's unclear exactly when it was mailed, right? And whether or not at that time was he still incarcerated on the date of the mailing?
Your Honor, I would represent to this court, being the law firm, that we would have, in all probability, checked to make sure that he was still incarcerated, or we would not have sent it to the Washoe County. So I would represent to this court that I believe that the document being sent to the Washoe County Jail was in fact done as a result of checking whether or not he was still incarcerated. So I would represent to this court that I would believe that he was incarcerated at that time.
Okay. Counsel, I hate to ask you, but I do, as you know, I need to, do you have any knowledge of it, or one way or another? I mean, or should I maybe call some other cases, let you check with your firm and
I can certainly check
recall
with the
this
firm,
case?
Your Honor.
Would you like? Would that make more sense maybe so that we can have a better understanding
Yes,
from a
Your
due
Honor.
process standpoint on a dispositive motion?
And I would appreciate the court's indulgence in that, and I will make that check and be able to give an affirmative answer to the court one.
Okay, so everyone, do appreciate it, but we're gonna need to recall this because obviously everyone can appreciate that that is a very important issue and a preliminary issue that needs to be addressed. So we're gonna recall pages 1 through 26 in a few moments, and instead we're gonna go on to our next matter, which is thank you so very much. Pages 1 through 26, case 831880, Richt versus Affinity Lifestyles et al. What I'm going to do, if it's okay with the parties, is there any counsel who did not previously make an appearance or any counsel who's requesting that this court have everyone remake their appearances? If not, I can say same appearances as when the matter was initially called. Does anybody request the court to have everybody remake appearances here in court? Anybody requesting that? Yes or no?
There's no need to recall here.
Okay, anyone remotely requesting that the court restate all appearances, or if I can just say I'm incorporating the appearances that were made initially. If anybody's requesting it, feel free to unmute yourself and let the court know, because I'll be glad to do so. No? Okay. Then we'll say same appearances. Anybody new appearance that was not on earlier? Okay, that not being the case, then let's just circle back to where we were. Thank you. So, it was Defendant Natural Foods, motion for summary judgment, document 320, filed on 7/28. There was an issue that you all thought that Mr. Richt was no longer incarcerated on or around the last few weeks. So, what's your proffer, please, counsel?
The proffer is this, Your Honor. Let me begin if I
Remember to
Jim
state
Neale.
your name and the party you represent, please.
Thank you, Your Honor. Jim Neale on behalf of UNFW and WFM, Whole Foods Market. The motion for summary judgment was filed with a certificate of service that is on page 17. That shows the address to which the motion was sent. That's the Washoe County Detention Center.
Which is what I read.
That is the same address listed in the plaintiff's motion to withdraw that the court entered as an order. And that, Your Honor, according to the Washoe County Sheriff's Office, is exactly where Mr. Richt remains today under the same booking number and
So he was not released 3 weeks ago? Or is there just a confusion? Is that what it was?
There was just confusion, Your Honor. He has been, and remains an inmate at the same address listed in both the motion to withdraw and in the certificate of service on the motion for summary judgment.
So, taking back the concept that he's out, right?
We apologize, Your Honor. There's no credible information that he's been released. All available information suggests that he's still being detained, retrial.
Okay. So, from a due process standpoint, are you asserting as an officer of the court that due process has been met and he was properly served the motion?
I am, Your Honor.
Okay, so now we have has there been any communications at all with him or on his behalf that you're aware of?
There have been none, Your Honor.
Okay.
There was no response to the motion, no opposition, as you know, to the motion withdrawal that the court granted, no opposition to the motion for summary judgment, no response to any of the discovery requests, no objections or requests for extension or explanation or anything of the sort.
Okay. Counsel for plaintiff, you need not answer this question, but I'm just going to ask just in a general, for the other plaintiffs, not including Mr. Richt, who you did withdraw in the court, you already done an NEL on. But is there any information that you are aware of that the court should be aware of?
I would just concur. I did a quick search that it does appear that he's still incarcerated in Washoe County. And the address is still the address that we had provided. In our motion to withdraw, we also provided his Las Vegas home address just as a secondary. But I have no knowledge that he gets mail at that address. I was in contact with his defense attorney at one point, and she provided him the motion to withdraw, is my understanding. But other than that, that was the extent of my interaction.
And like I said, and counsel, just a friendly reminder, as much as I said counsel or plaintiffs others, would you mind just stating names if we get nicely clearly for the record again?
Yeah, Brianna Switzler, and that's for Alexander Gonzalez and Addis Nova. Thank you.
And not Richt. Okay.
Correct.
Okay. Right. So when the court saw the certificate of service and compared it with the notice of withdrawal, that's why the court was really asking the question, because there was 2 addresses, right? And then you also then said, and I didn't see that there was the Las Vegas address, but okay. So you're saying due process because he's still incarcerated, he would have received this. Okay, next procedural hurdle. What does the court do from a due process standpoint, from your position, with regards to the fact you have someone incarcerated and you have non-compliance with the Judicial District Court rules, and whether or not somebody who's not experienced as a counsel would somehow think whether or not the court could or could not move forward with today's hearing because of that non-compliance issue. Would you like to be heard on that?
I would, Your Honor, if I understand correctly. And let me apologize at the outset for the non-compliance. I think if I understand correctly, the issues that the court's identified are twofold. Number one, 2.27A, which requires the exhibits being page numbered in the bottom right if there are more than 10 pages. And we did not comply with that. We provided the exhibits, we complied with
Provided
it.
the exhibits? Court never got a courtesy copy.
Your Honor, that's, as I understand it, the second issue, that's 2.20H. I believe that subsection requires courtesy copies for contested motions. I hope my reading of that rule is not wrong. That was the reason we didn't provide a courtesy copy to the court, was because it was an unopposed motion, Your Honor. If we should have in that regard, that's fine. I don't think that either deficiency, Your Honor, affects the substantive rights or the notice that would have been provided to Mr. Richt, nor does it go to the merits of the underlying motion.
You wish the court to address those? EDCR 2.27. So how would the court know what's being referenced when there's no page numbers with regards to what you are requesting in your motion?
Your Honor, I think the motion makes clear which exhibits we're citing to. I think it's 2.27C, which requires that they be separated and labeled. I believe there's compliance with that rule. I believe...
Excuse me. 2.27A. Exhibits that are submitted to the court that are in excess of 10 pages in length must be numbered consecutive in the lower right-hand corner of the document. Exhibits shall be separated by sheets with the identification exhibit blank, end quote, centered in a separate page in 24-point font or larger. C talks about scanning, but it's not a matter of A versus C, it's a matter of the mandatory language, right? And so
the pages are not numbered in the manner that 227A.
they're not numbered at all, right, counsel? It's not a matter of not being in the right-hand corner. They're not numbered, right? There's 89 pages in your total document, and there's not a single number to be able to reference between the actual pleading and the attachments of what you're referring to. Isn't that really the issue? It's not a matter of it being the middle versus the right or the left being the right. It's not there at all. It doesn't reference, and they're long exhibits, right?
There is no distinction between the page numbering of the exhibits and the motion itself. The court is, of course, correct.
You're saying you do not believe that that affects due process?
I do not, Your Honor.
So what are you going to do about the rule violation?
I'm going to abide by whatever corrective action the court imposes, and I'm going to be certain that it's not repeated.
Sounds to me like, well, someone planning on doing a voluntary donation to a 501c3 that engages in legal aid type services here in Clark County. Is that what's being requested, or are you requesting something different? That's not an order, that's a question.
Your Honor, that seems to me to help the lesson resonate, and I will accept the court's suggestion in that regard and certainly comply.
It's not a suggestion, it's a question. I mean, I'm asking
Your Honor,
you,
yes,
realistically, everyone wants to move forward with the actual motion. I need to, of course, due process first and foremost, right? Fairness, equity to everyone, ensure everyone has an opportunity to be heard, but you also have to ensure compliance with the rules, right? Because that way it's fair and equitable to everyone.
Of course.
So That's why the court just was asking you what you were suggesting. Anybody who's appeared before this court usually knows that sometimes, nobody wants to issue sanctions that are reportable, okay, unless they really are to a situation that is the only option, try and provide other potential options. Oftentimes people come up with options that they think might meet the needs. Sometimes if they don't think anything should be done, the court's not precluding any response, the court's just asking the question. So counsel, what do you think is appropriate?
Your Honor, I think that a donation to an appropriate 501c3 engaged in the provision of legal services for the less fortunate will certainly make the lesson all the more memorable.
Okay, we'll status check that in 2 weeks. Okay, so now let's get to the substance of your motion. I'm going to give an advance notice heads up to those of you who have joinders. There's going to be a question for those of you who have non-substantive joinders based on the actual missions and how they can apply to you in their missions that are company specific. So, counsel, that doesn't apply to you. I'm giving the heads up to the joinder people who are going to be possibly speaking in a moment. So go ahead.
Thank you, Your Honor. As the court's well aware, Mr. Richt is one of 4 plaintiffs in this case. He is the only one of the 4 with claims against UNFW or WFM. This is a 9-count complaint, and they're the operative complaint. That's the 3rd amended complaint, Your Honor. And that's Exhibit A to the motion. The first 5 of those counts pertain to UNFW and WFM. Those are strict liability for failure to warn, breach of implied warranty, negligence per se, negligence, and strict liability for unreasonably dangerous, respectively. As the court's aware, Mr. Richt's counsel moved to withdraw on 5/22/23. Mr. Richt did not oppose that motion. Mr. Richt's former counsel alleged, quote, insurmountable communications obstacles. The court granted that motion on June 16th, 2023, and identified in the order with former counsel's assistance, identified Mr. Richt's last known address as the Washoe County Detention Center. Discovery was served by UNFW, Your Honor, as we've mentioned, and Whole Foods Market on June 21st, 23. That was in the form of both requests for admissions, interrogatories, and requests for production. I think, obviously, the requests for admissions are the key discovery request here. Those are Exhibit B to the motion. The certificate of service on those makes clear that Mr. Richt was served at the same Washoe County Detention Center address. Each of the first 10 requests for admissions, Your Honor, deals with, in a pair, each of the 5 counts against UNFW and Whole Foods. So, for example, count number 1 is the unreasonably dangerous count, Your Honor. And RFA number 1 identifies, asks the plaintiff to admit an essential element of that claim. No responses were provided. Of course, under 36A3, the request should be deemed admitted. But for example, request number 1, strict liability count, admit that with regards to your first cause of action in your latest amended complaint for strict liability, defendants UNFW and WFM, Southern Nevada, are not strictly liable to you. The second request, is paired with that and says, admit with regards to the first cause of action in your latest complaint for strict liability that you did not sustain any damages associated with this claim. Each of the next 4 counts in pairs, just like that, Your Honor, asks Mr. Richt to admit an essential element of each cause of action with no responses and with what I hope the court will agree should be deemed admissions. Each of the 5 counts against UNFW and Whole Foods Markets fails as a matter of law. So for that reason, Your Honor, we request summary judgment. As I mentioned earlier, from a due process perspective, there's no response, there's no objection, there's no request for an extension, there's no response to the motion. And so I think that nor are there any responses in opposition to any of the joinders. So I would hope that the court would agree that the defendants have done what they needed to. We've elicited authorizations from Mr. Richt. Those have not been provided. We've asked a series of interrogatories that I think the court will find fairly standard in a personal injury case of this sort. No responses to those. And we've gone through the requests for admissions, the first 10 of which I think are fatal to Mr. Richt's 5 counts against UNFW and Whole Foods Market.
And were those from the underlying documents the court went through, found, in the attachments, were those on behalf of your clients only? I only saw that they were signed by the law firms representing the 2 movements. Is that correct?
Your Honor, we served discovery on behalf of our 2 clients, UNFW and WFM. I'll allow counsel for the other defendants to address whether they should somehow apply to them.
Right. I'm making sure, A, you don't represent any other clients.
That's correct, Your Honor.
2, you did it on behalf of both clients, not just one of them. Is
That's
that correct? And the third is that there wasn't some type of joint defense agreement or something that has not been provided to this court that somehow broadened the scope of who that discovery was sent on behalf of.
No, the court is correct on all 3 counts.
Okay, that's what the court was just checking. Okay. I do appreciate it. Thanks so much. Okay, so let's go to joinder parties. First, I'm just going to do it in the date order that you all did it. So that means Hannah Instruments. You have a non-substantive joinder. Your position, please. Here's Hannah Instruments is no longer on the line. Going once, going twice. Okay, no one for Hannah Instruments. I'm looking at all the boxes. Right, all the boxes. Anybody for Hannah Instruments? Last call? No one. Okay, then the court's going to have to address that based on the papers. Affinity Lifestyles. Go ahead, please, if you wish to be heard.
Good morning, Your Honor. Nathaniel Carlson for AffinityLifestyles.com Inc. and Real Water Inc. We also served requests for admissions to Plaintiff Jesce Richt on July 5th, 2023, and did not receive any responses. Requests for admissions include admit that with regard to the first cause of action.
Counsel, can I stop you for a quick second, please? Counsel, can I stop you for a quick second, please? The reason why the court's stopping you is what this court only has for purposes of today's hearing, right, is the joinder that was filed on 7/31/2023, correct?
Correct.
Okay. In that joinder, are you contending that you addressed any admissions that Affinity sent out directly or attached any said admissions or any documents to said document 324 filed on 7/31?
No, Your Honor.
So how can the court address anything that you're saying? Isn't the court bound due process rules, right, specifically to only address what's actually in the joinder?
Correct, Your Honor.
The EDCR. So please focus your argument on what the court can, right, actually address, which is the non-substantive joinder. Let me be clear. I did not see any additional joinder. Are you saying that you filed any supplemental joinder after 7/31 or anything?
No, Your Honor.
So then we're focusing just on the joinder to the motion by United Natural Foods and WFM, correct? Filed on 7/31 as document 324. Is that correct, counsel?
Correct, Your Honor.
Okay, based on that joinder for the motion that's currently before the court today, how would that apply to your client?
We would argue that the requests for admissions that were applicable to the other defendants would also apply to my clients.
And which ones are you specifically referencing that are addressed in your joinder, counsel? Because we may be on a little different pages, because the only thing I have is a joinder from you, or on behalf of your clients, says comes now defendant affinities, okay, and it has all your titling, collectively real water defendants through their attorneys, Woodsmith, etc. For the sake of judicial economy, hereby join United Natural Foods West and WFM Southern Nevada's motion for summary judgment and plaintiff Jesse Richt's claims only. Through this joinder, Real Waters adopt as their own, if it fully set on the memorandum of points and authorities, exhibits and information set forth or attached, so it says, to this motion, Mr. Arney, or incorporate the arguments request for relief in this motion because the Real Water defendants maintain equally applicable. So, but there was no attachments, there was nothing attached, so what are you saying from the discovery? That's part of the reason why I asked counsel, right, for the move-ins, if there was anything that was filed on behalf of more than just his two clients, or agreed to be on behalf of more than his two clients. So how do those pleadings which were relied on in their motion for summary judgment with relationship to discovery, those two defendants sent on behalf only on their two clients apply to your client for purposes of the joinder, please?
Your Honor, we believe that the requests for admissions that were submitted to plaintiff are also applicable to our client, as you can see in request for admission number 2. Admit that.
Counsel, did you say that in your joinder? The reason why I was interrupting you, my apologies, is because I'm understanding what you're bringing up for the first time in oral argument, but this court, right, is limited to the pleadings before it, particularly since this is a situation, right, with a pro se defendant, particularly since it's an unopposed situation, but you knew it was a pro se defendant, right? So where does it say that you've carved out specific ones?
It was a non-substantive joinder.
Okay, is there anything else you'd like to say, counsel?
Not at this time, Your Honor.
Okay, thank you very much. Okay, let's go to NSF International's joinder, which was document 326, please.
Thank you, Your Honor. Martin Little on behalf of NSF International. As you know, Mr. Richt has a single negligence cause of action against NSF International stemming from a facility audit that was performed for Costco. We believe his request for admit number 8 is applicable and would apply and be dispositive with respect to NSF. In that request to admit, he's deemed to have admitted that he has suffered no damages stemming from or to his negligence causes of action against the distributor defendants. And why we believe this is applicable to us is this. If he hasn't suffered damages from consuming contaminated water to the entities that sold him the water, NSF is at least one step further removed from that. We didn't sell the water to him. At most, it can be said that our facility audit was negligent, and somehow that may have prevented, these distributor defendants from being able to sell the water. So, I think the analogy is the same. If he suffered no damages from consuming the water, he cannot be deemed to have suffered any damages from our facility audit.
So, counsel, yours was different. You actually had substantive, which is why I distinguished it in that. But request number 8 goes to the distributor defendant. So your analysis is that it's a secondary aspect?
Yes, Your Honor. We're new to the case, and we did not have the opportunity to serve written discovery on any of these plaintiffs yet. However, he admitted in request to admit number 8 to Whole Foods that he suffered no damages in connection with their negligence claim. And again, they sold the water. They're closer. There's a closer connection, certainly, to the entities that sold the water than NSF International that did not. So our position is that if he hasn't suffered damages from consuming the water to these defendants, then he would not have have suffered damages with respect to NSF's facility audit, which is a step further removed.
Okay. Thank you so much. Double checking, did Hannah Instruments happen to come back online? No? Okay. I don't see them. They're not here in court. Okay, so then I'm going to circle back. Defendant United Natural Foods West and WFM Southern Nevada. You get last word if you want it on your motion.
Unless the court has a question or concern, I think our position's on the record. Hope the court will agree that we're entitled to judgment based on that.
Okay, here's the court's ruling. With regards to defendants United Natural Foods West and WFM Southern Nevada's motion for summary judgment on plaintiff Jesse Richt claims only, document 320, the court's going to find it appropriate to grant summary judgment on two independent bases. First, with regards to EDCR 2.20, it was unopposed. In evaluating that under EDCR 2.20, the court allowed parties to provide this court an offer of proof that the due process aspects of service were met. That has been stated with regards to the due process standards being met, and so therefore it would be an EDCR 2.20 issue because there was a failure to respond. There's not been any request for any extensions. There's been no basis with regards to this is not an order shortening time or anything that would have precluded or minimized the ability to respond, and there's no basis that's been provided that there would not have been a response if the underlying plaintiff chose to respond, so EDCR 2.20 is appropriate. Independent of EDCR 2.20 on the merits. The Mass Supreme Court has stated that even though some of these are, quote, legal conclusions, if you take the totality of the written discovery, including the specific admissions which are deemed admitted under NRCP 36, there's been no request to set aside, so they are deemed admitted as of the date of this hearing, and so therefore those would qualify for UNFW and WFM motion for summary judgment. In addition, taking the totality of the written discovery, including the request for admission, still would show that there has been a full opportunity for a defendant to respond. In the absence of responding, the court does need to grant summary judgment in accordance with applicable case law, NRCP 36 and NRCP 56. It is so ordered. With regards to the joinder of Hannah Instruments, the court did offer an opportunity for oral argument. Counsel wasn't, I've called it twice, so the court has to look at the actual pleading. When the court looks at the actual pleading of Hannah Instruments joinder, which was document 321, it was a non-substantive joinder, did not provide any information on how the discovery, and the court did confirm with movement that the discovery was only sent on behalf of their two clients, United Natural Foods West and WFM of Southern Nevada, not on behalf of any other party pursuant to any agreement for any other bases. And so therefore, the court cannot find that that joinder should be granted because the non-substantive joinder does not set forth the appropriate bases on how discovery, particularly since much of that discovery does specifically set forth on behalf, not only the pleading paper says who on behalf it's from, the counsel signature says on behalf of which clients it's from, but even the body of the discovery requests, including requests, most of the requests for admissions, does specifically say it's only on behalf of those two parties. To the extent that you could view some of the other requests for admissions don't specifically set forth those two entities, they are set forth, and it's even stated by counsel in his oral argument on behalf counsel by United Natural Foods and WFM that they were basically pairs. They walked through her legal statements and then the damages provision. And so when you look at that, plus there is no definition in the underlying discovery that sets forth that any of the terms distributed defendants, etc., would somehow include other parties for purposes of plaintiff's response to those discovery. I can't take the fact that there may be a definition in a complaint to somehow mean that that's what United Natural Foods West and WFM Southern Nevada somehow expanded discovery on their own pleading paper on behalf of only their own clients by their own counsel, not representing anybody else, somehow could be viewed to be broader in scope, and that's why the court did ask those clarifying questions. So therefore, the court needs to deny the joinder of Hannah Instruments because it's not appropriately showing how it would apply to them the underlying basis of the motion for summary judgment. The same analysis the court just stated would equally apply with affinity lifestyles. Remember, the court can only take into account the actual joinder of the motion that's before me, which would mean document 324. It can't take into account information that's never been presented to the court, what may or may not have been done. So therefore, the court also, the same analysis it gave for Hannah, would equally apply to affinity lifestyles, non-substantive joinder, and that gets denied without prejudice as well. We now go to NSF's joinder. NSF's joinder, document 326, had substance to it, but the challenge here is that realistically, I have to take into account, I've got a pro se plaintiff who was responsible for it. I have the nature of the underlying discovery, once again, only sent on behalf of two parties, clearly on the letterhead, stationery, of the counsel stating who it was on behalf of, signed by who it's on behalf of, with a lot of different of the admissions specifically stating those two entities. So it would not be, under a due process standpoint, reasonable for a pro se individual to somehow understand a failure to respond to specific discovery by United Natural Foods West and WFM Southern Nevada would somehow apply to another party that was, in fact, even recently joined. And so therefore, the court can't find that from the plain language of the underlying pleadings that they would support NSF's joinder to defendant United Natural Foods West and WFM Southern Nevada's motion for summary judgment on plaintiff Jesse Richt's claims only. So therefore, the court needs to deny without prejudice the reasons stated NSF's. The court's ruling, obviously, with each of those joinders only with regards to the pleading before the court today. It's not taking any position on anything prospectively. The court does not give advisory opinions, nor can it. It is so ordered. That means counsel for United Natural Foods West and WFM, you need to provide within 14 days EDCR 7.21 to the DC 31 inbox in accordance with the administrative orders. Said order under 56, you do need to ensure that you submit a copy of proposed order to Mr. Richt and need to set that forth when you do submit the order to the court. Now, normally it would be just a couple of days to a person, but since you're going to need to be sending this by mail up to Washoe, please make sure you give sufficient time for him to not only to receive it, but to have an opportunity to review it before you submit it to the court. It is so ordered. Is there anything else the court can do for defendants United Natural Foods and WFM?
No, thank you, Your Honor. Thank you, Your Honor.
And the court will put a status check for 2 weeks for Friday to see if any voluntary donations that were provided. Okay, anything else I can do for any other party to this case? No? Okay. Silence I'm taking as a no. Giving you an extra second to turn off your mutes. Nope, nobody was wishing to. Okay, pages 1 through 26 is complete. Have a great rest of your day and week. Thank you so very much.
Thank you, Your Honor.
Okay.